Heyo, and welcome to this glorious Thursday. Yes, it's Thursday today. On today's menu is Attorney Ashley Merchant before the Georgia Senate Committee investigation into the alleged misconduct in the Fulton County District Attorney's Office. We have seen some of this in the Fani Willis disqualification hearing. But holy crap. This was so much more than I could have ever anticipated. Now, a committee hearing is still under oath, but there's nobody to object that. I mean, the committee is asking the questions, and they will get answers. So not 15 lawyers for the district attorney's office who jumps up and scream. It is Miss Merchant or Miss Merchant, Ashley Merchant before the committee, and it is amazing. Yeah. I'm just going to get right into it. She testified for 3.5 hours. I'm going to play this in 1.25 to start with. Let's see if we can get it to 1.5 so we can get it in decent timing today. But yeah, I listened to this the entire hearing yesterday, and it went by this quick because the information she shares, oh, it's good. Oh, it's good.
Our minority leader, Gloria Butler, I think they're both en route, but we do have a quorum, so we'll call our meeting to order. This is the Senate Special Committee on Investigations. We have issued a subpoena on February 28th, and that was issued to Miss Ashley Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We also subpoenaed her to testify before the committee this morning, as is permitted by our rules. Ms. Merchant responded to the subpoena, and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any committee member to review at your pleasure. Just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The Minority Whip took some time last night, and I think he may have been the first person to really review all of the records and spent a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all of those documents will remain confidential. I remind the committee members, in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony, but I will ask you, Ms. Merchant, to let us know if anything, in your opinion, is confidential that you would not like for us to publicly disclose for whatever reason, and then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly, but just to sort of set the ground rules here.
And hello, you over at Rumble and on Twitters. Oh, again, this is going to be good. I promise you.
I will conduct the interview with you. You will be sworn under oath. Miss Brenda Elwell is our court reporter. She will be making a transcript of all the proceedings, and that will be publicly disclosed for the press if you want to go back and double check and see exactly what was said. That will take a couple of weeks to prepare that transcript, but this meeting is also being live streamed, so it should be easily accessible to the public and anybody interested in this. I'll begin. Ms. Merchant, you are here under a subpoena to testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Right. So, well, if you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's saying anything, let me know. The way our procedures work is that I will be asking the questions and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, et cetera.
Definitely. My name is Ashley Merchant. Ashleigh. Last name Merchant, M-E-R-C-H.
You're going to need to pull that mic a little closer to
Thank you.
So
is it okay? I have a notepad just in case
You're
I get
absolutely
two
free.
questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, et cetera. But since you are an attorney, apparently you're very comfortable responding. Okay, didn't mean to cut you off. Let's just make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004. So I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights. And then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes. Yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive award about my work defending the Constitution.
Yeah. So you are the current president of the Criminal Defense Lawyers Group?
Yes, yes. And it's the Georgia Association of Criminal Defense Lawyers. We go by GACTL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
Okay. And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex.
Yeah. Ms. Merchant was a bit criticized in the Fani Willis disqualification hearing, and she was, but yeah, I mean, she did come through a bit disorganized. This is a completely different scenario, completely different.
Felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals, appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies, so anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
Right. And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, I think it was late August, to represent him. He lives in out of state, does not live in Georgia. But so I've been his defense attorney since the time of indictment.
All right. So late August or September of 2023.
Yes, I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23. And then I negotiated bond for him, walked through the turn-in process and began negotiations with the prosecutor.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers, there's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section.
So that's the alternate elector process?
Yes.
And those are the documents that are deemed to be false there?
Yes,
Okay.
That's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump.
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman.
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there were some financial documents that are not redacted, and so those would need to be redacted.
Yeah, this is a Senate hearing, which means no defense attorney or no attorney for Mr. Bradley is there and can claim attorney-client privilege. So it is her judgment. Now, I do believe that she is good with it and that the protection in the disqualification hearing was a bit too broad. And you will all understand why in a minute, well, later in this hearing.
That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he given you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective.
And hello to Gigi, my first and best moderator. Everybody say hi to Gigi.
Order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but everybody else may not.
Yeah, definitely. Okay. So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that. Yeah. But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents, the documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated?
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state. Okay. And nothing was subject to that protective order. I went through and was very clear on that. Okay.
And I'm wanting to make sure of this because this committee has made it clear from the beginning it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all, or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order protecting, so I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury.
This becomes important later and is important now that Mr. Roman, who is now in the RICO indictment in Fulton County, was not subject for the special grand jury. Nothing about him was in that special grand jury. And Ms. Merchant will explain it thoroughly later on in this hearing.
But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury. And I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury, and so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did, yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, a special purpose grand jury process, to bring in testimony and bring in witnesses from out of state. They issued a lot of target letters to people back and forth. There was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding.
Yeah. Apparently, the district attorney's office didn't really want to hand over any immunity documents or stuff like that. So they have to get it through a court order. That's transparency for you.
And there's this transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded, and then maybe a section wasn't recorded, and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in the special grand jury process or in seeking the indictment? Yes,
they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Yeah. Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
Right. And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order, and I can review it. I brought some of the pleadings with me, but it was authorized. sometimes, so he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or
Yes.
impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that, but I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first,
just so you'll know why we're asking.
Mm-hmm.
The scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
Right.
some of these public. And there's, of course, a public, outrage or uproar or concerns about some of the alleged improprieties that you brought forth, both, within the in the system, kind of what's appropriate conduct,
Right.
And also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes,
Right.
or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I'm going to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. But so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it. And so we got a lot of arguments from the state about, well, the Attorney General's office does it. But that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues. And so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict. And if there's a conflict, you'd have to hire someone who's outside the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners. You've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area.
Okay, so John Dalton is here and is trying to scam you out of cash. That's a scam account. I've been trying several times to hide him from this channel. He keeps creating new accounts. So, yeah, he's out again. This time, ran out of gas, daughter HRS. Another time it was cancer. Previous time before that, it was legal trouble. So it's a scammer. Apologize for you to see that before I got to hide another account of his here. Sorry, but he's gone now again.
So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it, and it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of those.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done it.
Fulton County is one of them.
Only 2. Well, yes, I'm sorry. It's 3 counting Fulton County. Okay. I did not send an open records to Fulton County on that because I already knew that they did it. Is
there a statute that authorizes that?
There is a statute, and I cite it, if I may, I cite it in my brief.
Feel free.
Okay, thank you. I don't want to misquote it.
She is all prepared for this.
So it's 15-80-20. And how I came to learn that is I actually contacted the prosecuting attorney's counsel early on in this case, and because I was trying to figure out the legality of this. I did open records and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in
the special prosecutors is the largest personnel budget in the DA's office. That's really interesting because, I mean, if you have the budget, hire them, because this crap with outside special prosecutor, that's incredibly it's more expensive than it needs to be, and they will go into this later on in the hearing.
DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand, and that's what I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 15-18, the one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000.
What is that statutory rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000 $150,000, and that's one of the top paid people. So most of the people are paid, somewhere between 100 and 150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney? First, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually open records that, and it was declined. So we actually have a pending open records lawsuit.
The district attorney's office declined an open documents motion because they don't want to tell anybody how many people they actually have hired as assistant DAs. Which is scary because that's taxpayers' money. It should be of no question for them to reveal with the question, how many assistant district attorneys have you in the office? We have this many. Shouldn't be an issue.
Which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending. Because
it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys.
Do you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion? It's
controlled by the county, and I do know, I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer, though. Depending on who you are, in Fulton County, depends on how your budget is approved. So for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills. They do all of that stuff. So that's what happens at the county attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole other issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position. And I was surprised. So I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County.
She asked for money to hire 55 additional assistant district attorneys. Let's find out what she actually used that money for.
Commissioners and asked for it.
When was that? Do you know?
I do actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021 is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened. She was awarded that money September 15th, 2021. And she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So Ms. Willis asked for additional money to the budget to hire more assistant district attorneys to take care of the backlog. That was her presentation to the budget guys in the county. Take a wild guess what she's using that extra money for. Just
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the County Commission in September of 21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes,
Okay.
that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay, so this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county?
Yes. Yes, it is.
Okay, all right, so what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval. So, the statute says it already. When you were asking about changing statutes, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place, and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech, where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made that denial, the DA's office or the county?
The DA's office. And I did bring the open records lawsuit just in case you had any questions about that. So it was
denied by the DA's office. Open records should be public, should be okay. Here you are. But they deny it. And for me, the only reason to deny it is because they have something to hide. And as it turns out, they have.
The county, and I can tell you when I filed it. Let me see. And we went back and forth, and I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fani Willis.
He is, and he's also the one who who went to the Board of County Commissioners whenever they needed funding. So if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office, and he had to go and testify in front of the Board of County Commissioners to get that paid because they we're not paying it. So he's sort of the go-between with the board of county commissioners. His official title is something like chief legal officer or something like that, but he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't. And I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it. We don't have to do it. I'm a constitutional officer. So their argument was, we don't have.
Yeah, there's a loophole. Once you get the money, you don't have to oblige to what you asked. What the reason you asked for it, you don't have to comply to it the moment you get the money. Sounds like something that should fall within the RICO statute, wouldn't it? Misuse of public fund.
Have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members, and so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for special attorney general.
Yes.
Not attorney general.
Special
DA.
counsel.
Okay,
Right. Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute.
That they have, once they're awarded the budget, they can use that budget however. I mean, how their motion, and I'm happy to send the motion, it's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, or their position is the county authorizes a budget and she can pretty much has inherent authority to do it however.
Yeah, the district attorney, Fani Willis' position on, I don't care. I asked for it for this reason, but I can use it however I want to. And we kind of know what she's using that extra funding for. Over-the-top, expensive RICO trials. That is what she's using that extra money for. And why is that? Well, up until very recently, she had aspirations for the Attorney General's position after her term ends on the end of the year. I saw a tweet a couple of days ago that she was again qualifying herself as another term as a district attorney. So it might be that she's running again as just district attorney for an additional 3 years. She has no shame, Miss Willis. Absolutely zero shame. And she is the one who is supposed to get criminals to trial. No shame.
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
Yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have a code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or, you know, whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No. So, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, you know, that she would be the one that reviewed the time. So Ms. Willis reviews the time and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. You know, they don't actually like look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
Okay. And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals.
Valerie, I agree. $250 an hour for an attorney is not that much. Here's the caveat. This is the district attorney's office, which can hire a special prosecutor for an annual salary, which is somewhere between $100,000 and $150,000 a year. Mr. Wade gets $250 an hour. He has a cap of $35,000 per month. Coincidentally, he always reaches that cap. Always. That is how his billing is now $700,000, because he always reaches the cap. Isn't that weird? Every month he reaches the exact cap. With claims he does more work, but we only have the bills. We only have the bills. And it's still public money. And they didn't ask the county for money for a special prosecutor to do a RICO trial against 19 defendants. Never happened. They asked for this money so they could take care of the backlog. And they don't, in my opinion.
Submit bills on a, like, itemized statement on what services they've rendered?
Yes, and the Attorney General has very specific guidelines on that. What you can bill for, how you have to bill, and you know is told to remind. There's a reminder that this is public service. So you know, essentially be judicious in your billing.
Right, you go voluntarily get underpaid to be able to help the public.
And a lot of people view it as public service.
Are those bills submitted in like tenths of? I do some billing, you know, in my job, and it's usually tenth of an hour. Yes. Are there rules or guidelines or sort of standards of practice and how you bill?
Yes. So most law firms, I know because my husband used to work at a law firm, is 6-minute increments, and that's how most lawyers bill in the.
Valerie G, excellent questions. I don't think that's weird. I work in contracting. Often the folks who we are working with go over, but we cannot pay. We just call that personal time waste. I agree. I'm a union rep. I do labor law. I see these contracts all the time. But it's obvious to you. I can see it as well. So why does the district attorney's office want to hide it? Why did they ask for money for one thing, knowing, in my opinion, they would use it for something else? Why the secrecy? If it is this common or not weird. That's the thing that bugs me in this hearing, at least. Why the secrecy? They could have asked for money and then have that specific sealed. There's a lot of ways to, if you don't want it public knowledge that you're working on a specific case, you can, we need a special prosecutor for a RICO trial, and we ask that you in the county committee seal this budget proposal. Yeah, the public defender's office is, that was a hearing of its own in the Young Thug RICO trial. Jesus Christ.
Private sector, public, it appears that most of them are in 10-minute increments. I know that that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
Honestly, I would have to go back and look. They were very small bills, though. They were making less than $2,000 a year, so they were small bills. And
exactly, Valerie. Why hide everything? Because now we can only assume things, and when you assume things about a government entity, always assume the worst. Always assume the worst.
They were project-based, which I think is also different. They would be hired to do a certain project.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. They would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly.
This process circumvented those rules and ethical obligations?
Yes, it did.
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
I interrupted you. I'm sorry.
That's okay. No, that was the answer. So if she had hired Mr. Wade or somebody else as a salaried employee, they would make around $175,000, most likely.
So using this technique that didn't obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
way more than he would have made as an employee.
Way more, and also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Okay. Senator Dolezal, will you give us an example of one? I think we have one we're just going to pull up randomly, kind of. Okay, is that an example of the type of invoices he would submit?
Yes, it is. And so
that's an actual one, isn't it?
That is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Ms. Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So we had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right. Well, I'm noticing it lists the day in just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that.
Valerie G, you are an amazing source of information. Please never leave my chat. Valerie says, for those not from Atlanta, the Atlanta mayor's office had an inquiry similar to this around government contractors with Kasim Reed. You can probably Google it. I will. Thank you so much. It was a kickback type of inquiry. Thank you so much. I will look it up. I will actually look it up while we listen here.
So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office. And I have been told that he had one, and those you'd be able to see when he went in and out. Okay. But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed?
Oh, completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days, team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. And we've obviously never seen anything that he specifically has drafted. But I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team.
Okay. This is what happened. Guilty verdict in Atlanta City Hall corruption trial. Let's see. This was 2022. Former Atlanta Mayor Kasim Reed's administration found Mitsubishi guilty on 9 of 12 counts. Because who helped Reed win election and then worked as his director of human services, was accusing of using her influence to funnel business to city contractor E.R. Jr. and Charles Richards. She directed roughly $17 million in city work to the two men and their companies in exchange for about $2 million in bribes. Both men pleaded guilty in 2017. Yeah, that was interesting. And I assume that was part of Fani Willis' election campaign to get rid of corruption. I also think she has a RICO case against dirty cops, which is ironic regarding the witnesses she has used in the Young Thug RICO trial, where now retired Detective Velasquez admitted under oath on the stand that he erased recordings of statements if he didn't like the answers. He only saved the recording when he got the answers he liked. Now, he didn't put it that way. He put it as, I knew they were lying, so I didn't bother saving the recording, so I erased it. But once I knew they told the truth, I saved that recording. Yeah, I would call it, once they gave you the answer you wanted, you saved it. That is textbook bad cop, in my opinion. The DA's office is using him as a witness in the Young Thug trial. Woohoo! Yay!
Investigation meeting. Then it's got team meeting and argument prep, and then meeting with team. Most of his billing is meeting with team. Team meeting, team investigation, team brain drain. He called it different things like that. But I went through, and that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments or.
As an example, now, if you don't know, I'm not US based. I do labor law in Sweden. I have to say I drive to a location. I have to have a record on how much time and how many miles I drove. On that, I need to have on record how long the meeting went, how long the negotiation went, how long I spent on this. Now, I'm salaried, so it doesn't really matter that much. But just to avoid any notion of any misconduct, I have to report everything. And here he just hand over a paper. I did those hours. Okay, what did you do during those hours? None of your business. Approved. Boink boink. Ugh. Pisses me off.
No,
More specifically, and does not really give a lot of identification of what's being done.
it gives pretty much zero, in my opinion, identification. I mean, this is not something that we would be able to submit to a client ever. I can't imagine. I mean, they would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. I mean, you have to be detailed in your bills, because that's accountability. I mean, that's the only way as lawyers we can be accountable. You know, our clients aren't sitting in our office while we're researching, so I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fani Willis that was approving these either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office.
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that there were, I think I reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury, and later in November of 21.
Yes, it did.
Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see, it just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. So, the head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was original.
Remember the name Sonia Allen. It will become important later in the hearing. Remember that name.
In the emails that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director, or chief assistant. She heads that unit. And she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp, on him testifying when, all of that stuff, and Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but I mean, no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it's like $550 an hour or something, to investigate deaths in the Cobb County jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Ms. Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Ms. Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died.
Yeah, so Wade and Allen was involved in trying to hide from families how their loved ones died in jail. And then Miss Willis hired both of them to work in the anti-corruption unit in Fulton County. Seriously? Jesus.
Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have a figure, but I've got the invoices. But he had billed quite a bit of money to Cobb County, but hadn't produced any documents. And so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything.
Isn't that similar to having no documentation of paying back in cash? So speculatively, Miss Willis said, oh, you're gifting me all of these things. What if they found out? What will we say? Say you paid it in cash. No documentation. They have to trust you. Kaboink, 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 kaboink. Yeah, get back with me, said sadly, had they not tried to convict or charge former President Trump, this would be still going on, unabated.
That's where
That was some years before.
that was some years.
Yeah, and by the way, this isn't even Trump's camp that actually found this out. This is Miss Merchant, who is representing Mr. Roman. Who, yeah. So it wasn't actually Trump who did this to Willis. It was Roman through his counsel, who has made an amazing job finding all of these things out.
I think it was in 2020, maybe.
So
it was
when
right
did-
before
when did
this.
Miss Allen get hired by the Fulton DA's office?
When Miss Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job.
So Miss Allen was kicked out when the new sheriff went into office, and Miss Willis immediately hired her. What's the relationship between Allen and Willis? How close friends are they? That Miss Willis, after her successful campaign of becoming the district attorney to clean up in the swamp, to get rid of the corruption, make Atlanta great again. Another different kind of MAGA. Oh, I need to use that. Make Atlanta great again. Yeah, I know all these people know each other personally. I would assume so. If not professionally, personally. Yeah, it is nepotism. The very thing she said in her campaign she wouldn't do. The moment she sat down in that chair, I'm going to hire all my friends. That way I can make sure no nepotism. Yeah, I know this happens over here, over the pond as well. Nepotism. It's especially when you get to second and third generation politicians who have never had a proper job. Then everybody does nepotism. Everybody.
And she was hired by Miss Willis to head the anti-corruption unit.
Okay. So from your documents you produced and your news stories that I've read it, apparently there were other special.
Yes, I'm having way too much fun covering this case because listening in and see corrupt elected officials get exposed, it's amazing. And in my opinion, after finding out that Miss Willis slept with a married man, I don't really care if it was before or after she hired him. You don't do that. It might not be illegal, but you don't do that. In my opinion, if you, man, woman, whatever, knowingly sleep with a married man, that makes you a ho ho ho, says Santa Claus. Yeah, I believe that both men and women can be hoes. But let's continue with this hearing.
Counsel that were hired by Ms. Willis?
Yes.
And to work on these specific RICO cases or election fraud cases?
Yes. So there's several. And so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So
now it is really time to pay attention, because now she will go into what Mr. Bradley actually knew, what he told her, what he sent her. Now it's time to pay attention, because if you remember the disqualification hearing, not much interesting. I mean, it was interesting, but you didn't really get to the core of it. We needed more information. Pay attention now, folks.
So they both got contracts the month that Ms. Willis took office. They got contracts to do what's called taint work, which is essentially if for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privileged. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure.
Right, exactly. And one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those, so they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who are Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Yeah. Not exactly prosecuting criminal cases now.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts, he was getting paid essentially from the law firm as well.
Right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other, on this case particularly, there's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases. So the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office?
Yes, Scott McGinnis. Fani Willis was disqualified when they went over the Georgia lieutenant governor because she hosted a fundraiser benefit dinner for his opponent, which made her not eligible to prosecute that case. So she was disqualified. So I would assume she's fighting this tooth and nail now to not be disqualified here as well, because it's very rare to be disqualified once, because she didn't want to be removed from that case either. They had to disqualify her. And here we are again. In my opinion, she is nowhere near suited for her position.
Office as well?
They have had contracts historically. They do not currently have contracts. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And Same case. And he
also, this will show up later in the hearing, how he actively hid money from his wife during the divorce proceeding. And that, in my personal opinion, I will not spoil it. It will be later in this hearing how he hid money from his wife. And it is vile the way he did it, in my opinion.
Experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings.
Did he have itemized billings?
Very much so.
And
yes.
What increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15 minute increments. And So did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well known, very experienced appellate federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high profile cases there, but just very well known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
investigations?
I might. Let's see.
Okay. You said Mr. Wade had about 700,000 so far?
Yeah. Oh, Miss Cross was under 100,000, I believe.
All right. So if she's under 100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while. So I was subpoenaed, or not subpoenaed. I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him. So I'm not sure if he actually did bill because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests, but when they did respond, they were very, very limited, very small bills.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them. And once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
Right. And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe, and the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting
I
to
believe the
see.
case. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamped copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024, and I have a copy, which
I don't have that. If you would provide us with
Happy
that,
to.
then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance
this.
to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade, and so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing. But Mr. Wade is always there. So that was one thing that I noticed. And I understand now that their response is that he sort of is like a case manager almost.
I don't know about today's hearing. I am doing sort of a recap of yesterday's hearing because I didn't think I was going to cover this because I thought it would be a very, very boring, uninteresting meeting with politicians in a commission asking a lawyer. I mean, you have all the ingredients for something completely dull. I was wrong. So I haven't checked if today's hearing is cancelled. If it is going, then I will do a recap on it tomorrow. Because depending on the quality of the hearing. Of course, this is a bombshell hearing. So, of course, I'm going to cover it.
So I guess that would be why he's always there. But I wanted to compare them and see.
Okay. I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly the ones that showed the trips to DC. We hadn't had but a couple of days to review all your documents, and I was I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with DC White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I was not. I joined it, but I didn't litigate it. And the state said that they had to meet off campus. So because they didn't have a record.
Yes, Valerie. It's usually because she's inserting the gossip. Yeah, this is not a court. Different rule set, different situation. So she can actually present much more than she could in court because there's nobody there to object to it. I mean, it's amazing. Oh, it's amazing.
Heard of it, I guess you have to have a record if you go into the White House, and so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting, and they had to have someone who had some source or something to get them to agree to the meeting. But that's what. So the motion to compel was based on this entry, and this entry in response, they said they were meeting with the DOJ and someone with January 6th.
Okay. There's also an entry, May 23rd. 22, travel to Athens conference with, what is that, White House?
Yes. And we tried to figure out what and who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there. But I don't know. Do
you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
In the discovery, they've got a lot of our discovery involves the January 6th. I mean, a lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow. And then, there's one of the other.
Why this is important has nothing to actually, remove former President Trump from the equation. The White House is not supposed to interfere or intervene or tell any state's district attorney how and what to prosecute. And that goes in all directions. They are supposed to be separate entities. That's what's disturbing here. I have no skin in the game. I am not American. I literally have no skin in this game with the politics. I honestly don't care if it is orange guy or senile guy who wins the election. It really has no effect on me. But I believe that makes me the perfect person to comment on these criminal investigations. Because I literally have no skin in the game. I can call it as I see it without any political affiliation.
Things I did was I did open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the vice president. Okay,
and so this is the access history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting for sure?
Yes. And my understanding is it's highly regulated who can access the White House. And so you have to apply in person or apply ahead of time. And then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by. And they track you. And I mean, that makes sense. They don't want anybody, lingering in the White House. But they keep that. And so they're called WAVE records, I believe is what they're called. And I'm not sure what that's an acronym for, but they're publicly available. They're open records.
And this record that's shown on the screen shows Fani Willis was a visitor with the POTUS. I presume that's Vice President of the United States.
Yes, it was.
And what was the date of that back in, was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that I think it's Dixon, the mayor of Atlanta was also there.
Okay. I will take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess.
All right. Yeah, so far, really interesting. Let's skip over that recess. Oh, there, let's see. 1:08, 5-10 minutes. That's 10. That's 15. 20 minutes later, they are back. They are as good in timing as Judge Glanville.
Practices, the contracts that the various outside counsel had, and I pulled up here one section of Mr. Wade's bill for the really early on in his involvement in the case. As I recall, it began on November 1st of
Prepared cases for pre-trial. That is Mr. Wade's itemization. I would be fired if I presented anything like this. And look, 11/5/21, billed for 24 hours that day. Now, it might be as he claimed that he was done with the work, and then he calculated 24 hours and billed it on that day. That's not how you do it. You bill it, because this could mean, he has a cap of $35,000 per month. Everything above that, he don't get paid. Doing this crap means that he can move over to the next month and bill it, because if, say, he reached the cap in April, then he can skip a few weeks and bill it the month after as finished work. You're not allowed to do that. In my opinion, this is fraudulent behavior, and this is taxpayers' money. I mean, I would be fired in an instant if I tried to pull this shit off. In an instant.
21, so this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day. What do you make of that?
I mean, I thought it was astonishing that, you didn't sleep for 24 hours. I've been to trial. I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed.
Well, it had to be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day?
It had to be. At least. And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like, my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office, where his two law partners are doing the privilege review at the same time. That's one, that plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes. Okay. Yes. The only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes. He's never worked on any other case.
All right. Let's see that other bill there, Senator Dolezal. All right, so here's another one, if you can see that. Okay, this is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that.
Right. I mean, it's more specific, but it doesn't say what, like, just for example, team meeting and argument prep. Argument prep for what? I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research. What are you researching? Researching statutory privilege, whatever it is.
Yeah. This one, he shows date ranges when it's over multiple days, like down at the bottom, 426 to 427, 18 hours, right. If I'm reading that right, or 16 hours. But on that previous one, he just has one date, 24 hours.
Yes.
And you say these are approved by Fani Willis. By contract, she has to approve these billings.
Yes, she does.
Yeah.
And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, the county, in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break, though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. The state filed a response. So this is DA Willis's response that was filed on February 2nd. They wrote on
This is a response to your motion to disqualify?
Yes, sir. Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as a winner and he got inaugurated, that following January. And this is years later, we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge, or prepare any legal documents at all?
No, not that I'm aware of. And that
Did he sign any pleadings as if he was the drafting attorney?
No, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it, and then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response, or their office's response, doesn't indicate that was ever done either.
And your experience when you...
That is really interesting, because they testified under oath in the disqualification hearing that he worked for free at some point, that he worked more hours than he billed for. Here's the thing, as a contractor, you still have to itemize it even if you don't get paid for it in the legal section. They will look at it, well, you want to bill for $42,725. Well, sorry for you, the cap is $35,000, so we will remove all of that. And that goes to why I did 16 hours that day, 24 hours that day. That, in my opinion, speculation, but still my opinion, he moves billable hours over to the next month so that he can always bill the exact cap. Isn't that weird?
You were doing like your public defender work, that you were reviewed and they cut your time.
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just pick up right when they were going to the appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped, he could not bill more than $35,000 in any given month.
Yes. And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. But so they re-upped the contract November 15th, and then it had a cap, but the cap was significantly higher. I mean, I don't remember the first cap, but it was not 35,000.
Here's a document you produced. I think you prepared this summary that shows all the payments that he received.
I just saw that StreamYard has a new thingy, because I was a bit weirded, because it says on YouTube I have this number of viewers, but StreamYard says I have more viewers. And now I see it's between YouTubes and the Twitters. So I have currently 44 people over Twitter watching me. Yay! Press that heart button over at X, people. Make more people know it. Yay! I had no idea. That's why I sometimes use the Rumble platform to stream from, because those are explicitly itemized. This many people watch on Rumble, this many people watch on Twitter, this many people watch on YouTube's. So because now I have to go over to the Rumbles and okay, there's 16 watching right now, and or something like that, and I have 75 on the YouTubes and 44 on the Twitters. I'm happy with those numbers. I'm really happy with those numbers. Those are great numbers for my little channel. Thank you so much. Remember, hit the like button. That way, YouTube promotes me to more people, and I would really appreciate it.
Either I did this or this might have come from Fulton County purchasing.
All right. So that was produced to you from Fulton County as
Yes.
all the payments he received?
Yes, this was produced from Fulton County, yes.
And what's the total? Is that just, my eyes aren't so good. What that looks like 22 all the way through 23?
Yes, 22 through 23. So so his first bill would have been paid in January of 2022. So he billed for time in November, December, and then you see those two bills. And so those were $15,000. I believe that was the cap. So in January he was paid for $15,000 for work in November, and then in December he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for $15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June. The order actually, but what happened was they started picking. So it looks like they started picking the grand jurors on May 2nd of 2022, and they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County. So I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies. And he was actually just a solicitor. And solicitors is, because you said not everybody.
Scott McGinnis says, I'm shocked mainstream media was covering this hearing live. They usually cover up the corruption. I picked this from 11 Alive, which is somewhat of an independent news agency. So mass media, yes, but more independent. So I support them. I have no idea of their political affiliation, but they show stuff other medias don't. And you should all support that. More competition in the mass media market.
May understand the difference between solicitors and district
We've got
attorneys.
an ex-solicitor on this panel, so I don't say anything negative about him.
So he can tell you all about it.
They prosecute misdemeanors, aren't they, right?
Yes, and in Cobb County specifically, they prosecute misdemeanors, yes.
Okay. It looks like he's pretty much hitting the maximum that he was allowed to under his contract?
Yes, most months he did.
Okay. And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task?
Always block billed. He never itemized bills, never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts, and I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one. And Ms. Cross was at the hearing, and she said, I can just tell you right now I don't have a contract. So I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Does Mr. Wade have a current contract?
Yes, he does. I also think it may have been, I don't know if it's disclosure, but I can tell you that they've changed, since I started looking at this, they've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check. And since I filed this, none of them have come up. So I don't know if he's not being paid anymore or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, they regularly came up, but now all of a sudden they don't.
Okay. So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January. I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
Now we are going into the real bombshells that I think most people will be interested in. What did Mr. Bradley actually know?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship and they had been traveling and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also,
you had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed. Or, I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So this document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said her filing, I at the break, I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't file what?
He didn't file an oath of office. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who are district attorneys in other jurisdictions who took a case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it. So I did open records to the probate court, to the Superior Court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand jury, grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a.
This was a problem until they filed the supposed oath he took. But they didn't file it until after she started investigating. Again, speculation. Did he actually swear an oath? Or did they just file it to get away with not following procedures? We can all speculate.
Grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret. And there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no.
Okay, I'm going down on normal speed, not 1.25, so you can hear if she has a southern accent or not. I'm not qualified to distinguish if she has or hasn't.
No public approval of these contracts. There's no oath of office filed. This is different. What's going on. We later found out that he had taken an oath, but nobody had filed it,
Okay.
And the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection, discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that, and then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year, and you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100, and I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100, So people do take that pretty.
Yeah, and gifts over $100, or either itemized or cumulative. I believe Georgia has cumulative in the statute. So you can't just take $55 lunches with somebody. That will become over $100, and then you have to file it. And I believe with all the travels, all the dinners, all the day trips, you are getting close to $20,000 from Mr. Wade to Ms. Willis, which she claims I paid back in cash. Yeah, isn't that convenient? And I don't care if she usually has a lot of cash in. Then you report it still at the time.
Seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County. So, and it's one of
That would
those.
include Mr. Wade, obviously, then?
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
That's exactly what
Hire
it is.
somebody as a vendor and they give you gifts in exchange.
Yes. And so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had or I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just, a lot of people said that. And so a lot of people were talking about that. And it was kind of surprising because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? How do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their like text messages. I mean, I was able to get get his geolocation data through subpoena. But the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say I only want text with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021, and it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were billing a meeting together? Like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd.
Here's a thought. Miss Willis says she is a constitutional officer, and as such, she doesn't have to comply with, she's beyond the reach, or doesn't have to comply with, and stuff like that. Isn't that impeachable in that case? The Georgia Senate or Georgia State has to impeach her? That would be really ironic, because if she claims she is above law and regulations as a constitutional officer, then you need an impeachment. Will they go there? I don't know. Honestly, I don't think so. Most of these people wants to be re-elected. And if they go against her too hard, because she does have a huge fan base who yells, who pulls the race card in every corner. I don't care about that because I'm not US based. So if you pull a race card on me, look at me. I'm comically white. I'm the result of 1,000 years of Scandinavian inbreeding. I'm too old to give any fucks. But it's still annoying when you show up with facts, because I don't care about Trump. Oh, you're a Trumpist. I don't care about Trump. You must be a Trumpist. And here's where I agree with the late, great Martin Luther King Jr. His dream was to look beyond the color of your skin, and you only get judged by your actions. And I agree. I could do this and nobody would see the color of my skin. Then you had to judge me by my character. But here I am. Dun, dun, dun.
So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at council table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like, they won't pay for two people to sit there. And so I wanted to look at that. But they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team, since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Back to your uncovering the relationship.
Yes,
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities.
Here we go. What did Mr. Bradley actually know? William says, with your accent, we will all know you're white. Yeah, it's kind of a tell. But now we are going into what did Mr. Bradley actually know. This will be so much more and so much more in depth than in the disqualification hearing.
So we're looking into how much money had been paid, because everybody in the case was kind of like, what, why do you have special counsel?
Case?
On this case, yeah. Like,
was
why
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's, it's kind of unclear, like, what month. The testimony is very unclear as to when they actually, I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some more open records. And Ms. Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation. And I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could. And I said, no, that's a conflict too. if you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours, who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad and I took notes on all the things to ask for open records.
So what did he say was really happening when he said, this is what's happening?
He said that they met at a judicial conference before, he was very specific that it was before she became DA, because that was one of the things that he could.
Hey, I got raided by Cat. Thank you. Thank you so much. I've seen you in my chat earlier. Do you have a channel now? That's amazing. Thank you so much. Thank you, Kat. That I really appreciate it. Welcome to the hearing that will explode it all. What Mr. Bradley actually knew about the affair between Miss Willis and Mr. Wade. And Miss Merchant here is about to reveal for the Senate hearing exactly what Mr. Bradley said and knew. In a court proceeding, in the disqualification hearing, this would have been objected to high and low. This is not court. This is a Senate Commission hearing. And she is about to spill it all out. Welcome to the show.
He couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married. And
I was told that my sound was low, but the court is good, so I raised my microphone a bit. Welcome everybody from the Cat Raiders.
Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college. So,
and Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been, yes. And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point, Mr. Wade represented himself, and then he hired a different lawyer. So I didn't know anything about the divorce at that time.
So Bradley did not like the way Wade had treated his wife.
He did not.
But he represented him.
He did not like the way he had treated his wife. He didn't like what was happening in the divorce proceeding. Yes.
Okay.
And I mean, I remember specifically him saying, I handle my business, things like that. Like, that I don't leave my wife without alimony, because and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out,
Yeah. Youngest dropped off at college. He got appointed special prosecutor, which would earn him a cap of $35,000 per month, and he filed for divorce, so his soon-to-be ex-wife wouldn't see a cent of that money. Stay-at-home mom, married for 30 years. Yeah, I know. This would never be admissible in court. But it is admissible because this is a Senate hearing. I'm enjoying this. I am so enjoying this.
And so we went through, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, they met at hotels. He would go to her place. And I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes, it was Robin Yeardy. It was not until sometime later that I determined that. It was very difficult to determine who that was because he did not remember her name. But
he knew her by sight?
He did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures or showed him a couple pictures of some other folks or
this
names.
Was in January of 24, right before your motion?
It was. It may have even been after I filed the motion. It was around the time. It was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office. They had a contract.
We just put on screen some of the text messages that you produced to us.
Yes.
This is from your phone.
It is. And
you're talking to Terrence Bradley, I see over there on the left.
Yes. And so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that is a picture of her. So it doesn't show up on this, but it's actually, there's a picture of her.
So while you're texting, you're shooting him a picture to see if he can identify Robin Yeardy?
Yes, yes.
Did he identify her?
He did, yes. He said, yes, that's her. That's the East Point. And he thought the apartment was in East Point. I later found out.
Oh, I'm so sad that... Can I do this? No. There, okay. Now you see, and you can see here, if you remember the disqualification hearing, he claimed he didn't remember anything of this. Look at that. That's January 14th, 2024. Not even a month and a half later, he has no recollection about anything of this. No recollection. And oh, no. And what we saw in that hearing, now we can see the rest. I'm a bit bummed out about 11 Alive keeping that banner over some of his texts. Because as you can see, he talked a lot to Miss Merchant. A lot. Get back to me. I hope he loses his license. Yeah, he's screwed. He's screwed. Hey, Kat. Thank you for sending people over. Thank you. I remember you from earlier in my... You've been in my chat before. I'm not subscribed to you. Now I am. Everybody go over and subscribe to Kat. Let's see here. I will post the link here. There she is. If you haven't subscribed to her, do that. Oh yeah, we are covering a bit of the Fani Willis hearing. Now my focus is on the Young Thug trial. That's why I'm covering this. You have Kat has another focus, so you get the best of two worlds if you subscribe to me and to Kat. So go do that. Hey, done. Good sell. Good sell. Let's continue.
It was in Hapeville, but those are very close in close areas.
So he knew they would meet at that apartment?
He did, yes. He knew all about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called Critical Mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. He, right after Miss Willis had opened the investigation in this case.
Okay, so they canceled the ethics hearing this morning. And I saw they are bringing up another person to run against Judge McAfee, and who apparently is a close friend to Miss Willis, allegedly. Yeah, they are the gang of nepotism, the corruption. They're closing the ranks.
That same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fani Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity?
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. So we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis's email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I'd never heard of media monitoring. I didn't even know it existed. No, it was very shocking. But so I got some of the emails.
Yeah, this media monitoring completely unnecessary and does not bring any facts relevant to this. So this is just but hey, here we are.
About this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlinks to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this Critical Mention profile. It's a platform that you can log into and see, how am I doing in the media.
So instead of hiring more people to actually prosecute cases, she hired people to do media monitoring. And why is that? Well, I already said it, but I can repeat it. Miss Willis was, at least, going for the Georgia Attorney General position after her term ends December 31st of this year. That might not happen now, but this is what somebody with political ambitions do. Are they talking about me in media? Is it positive? Is it negative? And then act on that. That's pure politics. Pure politics.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her and I asked Terrence, is that her? Because I found out she had been fired or been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her information, get an address, and that's how we were able to narrow down where this hateful condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet for their relationship.
Yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, just, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records requests or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one's to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis?
Oh, yes, the credit card statement. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay.
So, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
Is this the document you gave us from the Capital One there?
It is, yes. And there you can see, so Clara Bowman is Mr. Wade's mom. So this was the cruise that happened October 31st, around that date. Mr. Wade paid for Miss Willis, Mr. Wade, and then his mother's plane tickets, and then also their cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records.
And there are some people out there who claims they were not living a lavish lifestyle. You can't blame Mr. Wade for taking these cruises. He was a world traveler. And I simply asked him, okay, can you show me he did all this often prior to his appointment? No answer.
paid for this for both tickets?
Yes, this is from his financial records, and I tried to be.
Ah, damn. Boomered. Okay, let's count again. 3, 7, 10, 12, 14, 8, 15, 5 plus change, 16, 1 plus change, 16, 2, 16, 6 plus change, almost $17,000 in trips between October 28th, 2022 and May 12th, 2023. October, November, December, January, February, March, April, May. 7 months and $17,000 worth of travels. That's a lot. I mean, I'm planning my trip to the United States in August. I will visit Houston, the Missouri Convention, where you can meet me. I will then do a road trip from Houston to Michigan via Atlanta and Delphi. So I will be in Atlanta around the, let's see here. I should be in Atlanta around the 14th of August. I will visit the courthouse if I can. And if the Young Thug trial is still ongoing, I will try to get in there and maybe, hopefully, get an interview with one or a few of the attorneys in that trial. Yes, Diana Scholar, that's a road trip. I mean, if I drove everything in one leg, it's 25 hours. But I will have 5 or 6 days of travel in that. And so, yeah, I will do that road trip, visiting courthouses, because I covered the Delphi case in Indiana and covering the Young Thug case in Georgia. And then, yeah, so if anybody wants to have a meetup in Houston, Atlanta, Delphi, or Detroit in August, just let me know. I will post it here on my channel on YouTube when I am where at specific dates. So, yeah, but that's August. And why did I bring that up? Yeah, because that trip, airfare from Sweden to the United States, hotel rooms, rental car, gas money, stuff like that. My budget for the entire trip is $5,000. He spent $17,000 on 5 occasions on cruises and Belize. If I were to make this exact same thing, you have to calculate in traveling from Sweden. If you have some friends, you may want to confirm what the process is for getting a media pass. I'm on top of it. But thank you so much, Valerie. Thank you. But I have it in the works. Thank you.
There were a lot of Ubers and things like that. I did not include things like that,
Yeah.
I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
Right. And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California.
Yes.
These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced us?
Yes.
This summary, or is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Okay. Do either of them deny these trips occurred?
No, not at all.
And so is this the impropriety, the financial impropriety of getting financial benefit from the job that he's paying for her way on these trips with money
Yes.
that she's paying him and approving?
This is the what I would call undisputed. You know, the some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Ms. Willis.
So back to you're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court,
Yes.
and he spills the beans on it and verifies it. Then you go get the documents to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to.
Yes.
Yeah.
And you know, I developed it. You joke about my investigator skills. I've done public defense most of my career, you know, at some point or another, at pro bono. It's hard to get money for investigators. So I've learned how to do a lot of it on my own. And, you know, I dig a lot on things. So, and I do like to use the Open Records Act. So I was able to do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, you know, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong.
Yeah.
You know, I didn't want to make any allegations that didn't have support. So I would regularly verify with him, and you know, I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out, so he didn't continue this investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So, you know, I was able to independently verify a lot of things, which to me, investigating is important. You know, that the East Point location, that it was in Hateville. You know, Robin Yeardy actually did quit. You know, Mr. Bradley had told
Was
me
she forced to quit, or how'd that come
No,
about?
I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some, she was outspoken about she didn't like some of the things that was happening in that office. And when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do, because she did the communications. And so she quit after that, is my understanding,
Okay.
based on her testimony and, you know, the allegations and all the pleadings.
Right, so after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, or Cellhawk, what's it called, where you're tracking the
Yes.
location. You were mentioning to me earlier when I kind of got you off that.
Yeah, again, this is not a court hearing. This is a Senate hearing. Completely different rule sets. If this was in a court, Miss Merchant, wouldn't be able to say a tenth of what she is saying here. Now she can present the evidence and then add on all the gossips, because it's a Senate hearing. Yeah, Valerie, Mr. Bradley was blowing the whistle. He was blowing it so hard. He was blowing it so hard. Even Mr. Wade. No, I won't go there. Oh, it was. I thought. Where is it? No, not that one. I lost it. Darn it. Well, I will find it somewhere else. Let's continue.
Employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Okay.
So let me explain that, because there's two different systems, and you know, I'm always learning new things about this, but cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The Cellhawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. Cellhawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you know, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hateville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff, I'll talk about the text in a minute, but what we had our investigator do was narrow it down. We got all the raw data, and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which...
The location you're talking about is Miss Yeardy's condo.
Yes,
Okay.
It is Miss Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of the things, where he, you know, Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden his phone would travel, and you can actually watch it. When you do the live Cellhawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. You know, if you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, you know, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
And this is before he gets hired in November of 21.
Yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the cell hawk data, but that's the summaries based on what we had him do. And again, we try to be very, very narrow. There were a lot of dates that it looked like it happened also, but maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this? I mean, you already kind of have the date on it.
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing. We got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. I mean, it took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. But the other thing that I was talking about, so this is the CellHawk report, and heat map is just like how many times it's pinging, heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's CellHawk. Cellbrite is a different program. Cellbrite, and it's CELLEBRITE. Cellbrite is a program similar to CellHawk, but it downloads data in the phone. So like this one is you pinging off of towers. It's geolocation.
It's showing where you were
exactly
at a certain time.
Cellbrite actually can get your texts, your pictures, your app usage. I mean, all of that stuff. So it's one of those things that if you want, if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone, but you can also limit the data. So it's a very expensive program. So not a lot of people have it. So when I have my clients use it,
I might have a depiction of what happened. Miss Willis, Mr. Wade had an interesting relationship. Let's see what this rendering is. I'm having way too much fun with this. I'm having way too much. I don't know. Okay. Now, what this picture is showing is at what times his phone was pinging at a certain location and stuff like that. And it seems to be very focused around booty call times. Conveniently.
It's a lot of money for them to have it done, but the DA's office has it. They have the software, they pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So what I had mentioned earlier is
you have to have the cell phone to do that.
You do. You have to have the
cell
cell
phone.
So what
did Mr. Bradley give y'all his cell phone, or
no.
have to get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. We cannot. I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability. I don't have the ability. They have the ability to plug that phone into the Cellbrite and print out a report that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program and it would have shown no communications between them.
Yes. And it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that if they wanted to only limit it to we want to prove that we weren't talking romantically in November, they could limit it.
So they could have actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%. Yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other
Oh, yeah.
prior to November 1st of 21.
Yes.
How
and
did you find that data? Is that anything you've produced to us?
that is so the CellHawk data actually analyzes that. So you can see, we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember 2021, he didn't get the contract until November of that year. So most of 2021, he's not under contract. To over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront? We're not privy to what all came out in evidence at the hearings that you've had. Did you get either one of them to say that's not true? We didn't really talk 12,000 times? Or
no, what they did was they filed an affidavit saying that geolocation data is not always reliable.
Okay.
Yeah, a district attorney's office claiming that geolocation data isn't reliable. Another person, I can't remember, checked the filings in Fulton County Court, and Miss Willis, in prosecutions she did herself, has on at least 5 cases used this program to prove a defendant was at a specific location. 5 times, 5 convictions. And now she has the gall to claim it's not reliable. Sure, yes. I'm confused. Why did Wade's ex-partner give her so much information and now he wants to retract? I know that Nate, the lawyer, his theory is honey trap. Because Miss Merchant is a good-looking lady, and she's very blessed in the top shelf apartment. It's a theory. It's a theory. And he might want to get back at his former law partner after they threw him out. Lots of reasons. But in my opinion, he should lose his law license. And we are soon to get into why I believe Mr. Wade should lose it too.
Does that apply to Cellbrite data, though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use CellHawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same. There's a trial going on. It's called the YSL trial. There's the same data being used in that trial. And our investigator actually.
Yeah. I know. The YSL trial, that's the one I'm covering. I've been covering the Young Thug RICO trial since May of last year. And I'm still doing it. They are having a break right now, an administrative break until Wednesday. So that is why I'm covering related stuff and other stuff while I can, because the Young Thug trial will not end this year. I will be pleasantly surprised if it ends this year. We are in month 3 of that. I mean, early December, January, February, March. 3 months. And the prosecution is nowhere near done with their case in chief. They have 196 underlying acts in the RICO charge against Young Thug et al. And they have 771 people on their witness list. And after 3 months, I think they have called roughly 80 of them.
Analyzed it for them in that case. So I mean,
For them, you mean for the Fulton County DA's office?
no, for the defense looking at that data. So the point is they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
Okay, got it. And did your Cellbrite data come in? The existence of the cell phone calls?
No, so the Cellbrite data, that would have to be voluntary on part of the DA to actually
So they could show you that to disprove your allegations?
100%.
Okay, didn't do it?
No.
Neither Wade nor Willis?
No.
Okay. All right, so you've done your investigation. You've determined you think there was a relationship that had begun before.
Yes, I know the Supreme Court overruled the use of lap rigs in a trial. I suspect we will hear that motion on Wednesday from Mr. Steele, or a renewal of his motion to exclude lyrics as evidence in the Young Thug trial. Because now they have a Georgia Supreme Court precedent on it. And since they have already played a bunch of lyrics, I don't think they will apply for a mistrial. I don't think they will get it, because this judge has no interest in anything but seeing the trial go to the jury.
He was hired.
Yes.
And after having met with Mr. Bradley, you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes, I actually started the motion in September
cell phone,
and then added to it.
Messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes.
And was that because you didn't want to file a pleading that was inaccurate?
100%.
You wanted him to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney.
Yes.
Who probably knew as well as anybody in the state.
They had been best friends also.
Okay. All right. And so let's pull these up, Senator Dulles. When did you start? You kept these text messages somehow?
I did. So I actually, Mr. Bradley uses an Android, I believe. And so it was not easy to just download them. And I'm not the most tech savvy person. I also, there's a lot of text that just went into things that I didn't think I thought.
Yeah. Is this accurate? And he answers, thank you. But you can't put where they met. Not many people know that. I might be the only, not even Chris Campbell. Yeah, it goes to what somebody else said earlier. Oh, it was Valerie. Yeah, I agree. He didn't think he had to testify. He thought, I will give you this information. You will find the evidence so you can bring it to court without me. Here's the thing, Mr. Bradley. Miss Merchant represents her client's interests, not yours. If you wanted anything as a non-disclosure, you should have had your own attorney and had that non-disclosure written up. And you didn't. So here we are.
Just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abadi was the prosecutor.
Okay.
So he just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete. Rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word, but there were some that that Miss Willis's daughter had failed out, like things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that.
I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours, and I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you? All right, so up there on January 5th at 9:50 a.m.
Mm-hmm.
You're asking, what do you read the question?
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did, and I actually admitted. So at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it, and then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded, and then he responded that everything looked good. Because I asked, I said, I'm sending you this motion. I need you to look at it, and then he responded that everything looked good in it. he actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received, and I didn't know that it wasn't really highly relevant to my motion. But he was like, "Oh, that's going to tip them off that I'm talking to you, and he did not want anybody to know that he was talking. He was very concerned about what."
I'm going to let you just read through this, Jane.
Okay.
All right. We left off up there. Absolutely, it began before it began when she was a judge in South Fulton. When was she a judge in South Fulton?
She became a judge in August of 2019, and I did an open records. I first asked, I first did an open records and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the,
Who's both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So I found, and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when, all the conferences went virtual, narrowed down my timeline. So I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Ms. Willis went there because I was trying to fact check. And they said no. So I subpoenaed them and they gave it to me. I also subpoenaed.
Was she in attendance?
She was.
Where was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from 2 different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, Judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side.
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most, because he was in the city of Marietta. I mean, he was he was a fill-in judge for that. That wasn't his.
Okay, so you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green line. What's the next? If you don't mind, just sort of read us through.
It says, "Is this accurate?" And this was again on
So
January.
You're saying, "Is this accurate?" You're going over this brief and saying, "I'm about to swear this in court. Will you verify it's accurate?"
Yes.
Okay.
So at that time, I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court, and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12-something p.m. on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner.
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what? Multiple
reasons. I mean, it's a district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, he testified that he had never discussed this with me. And
then you showed his text message where y'all discussed it.
Well, at that point, that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Had told you that?
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not?
He acknowledged the relationship, yes.
Before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther King.
Walk us through that. What were the grounds why is it you feel like Fani Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not.
Yeah, this for her client is very important. Even though they have a special grand jury for this and this only, Mr. Roman was never in that indictment. He was added later on by Fani Willis. So there was actually no basis. She added him on later as a co-conspirator, not as an active participant, but as a co-conspirator. That, in my opinion, you shouldn't be able to do that. But that's the problem with the Georgia RICO Act. It's so broad and so vague, you can put almost anything in it. As underlying act, co-conspirators, it's mortifyingly stupid, in my opinion, the Georgia RICO Act. Yeah, as Gigi says, and Fani Willis called this woman a liar in open court on the record. Who's the liar? Fani.
Recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40-something people.
They had.
He was not even in that list of 40?
He was not.
And they didn't take, or they, as in Fani Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called Find Me the Votes, that authors had exclusive access to her. And so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. You know, and I mean, I have
that because they cut deals with them, immunity deals, or
some of them were that. Some of them I just don't think she wanted to bother with. You know,
then she added to the list though people that were not even recommended. Or at least your client.
My client, yes,
Okay.
She added him, so he was one of the ones. So there were some people, you know, and it's publicly available in that book, like Senator Graham, Loeffler, those Purdue, those people.
They recommended prosecuting them.
Right, she had considered prosecuting them and taking them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, you know, why would you want to expand it? You know, there's different ways you can go about prosecution.
You figure out why they add your client to the list?
No, but the my allegation in my motion is that, you know, the bigger the case is, the more money that's made, and that, you know, that made sense to me. So for me to file the motion to disqualify, obviously we had to have some type of a basis, you know, besides all of the violations, and so expanding litigation. Because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, follow me down the path, if you only indicted one person and it was narrow, you know, you could try it in a month. If you indict 19 people and, you know, 3 different essentially alleged criminal schemes, you know, like I divided it up earlier, that you now have 3 years of trial. You know, you've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution.
Yes. And so to answer your question, you were saying, walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, you know, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it. And at that point, the world is shocked. I mean, shocked, because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley, that next weekend, you know, he gets some calls he gets a call, you know, trying to fish to see if he's the leak, is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fani Willis.
Yeah. It's a clusterfuck. It really is. So an attorney represents the law partner of Wade. That attorney's wife works for Fani Willis. That's, in my opinion, is a conflict of interest. Now you can work as husband and wife on different cases, as long as you keep not only a wall in between, but different areas of the house entirely. And when they represent, husband and wife represents different parties in a disqualification hearing. I know how it's pronounced. My pronunciation is much more fun. And I'm Swedish. I can get away with it. I know it's Fani or Fani or yeah. I know Fani isn't the pronunciation. I use it because it's funnier. Thank you, Jacob. Now, what happens in the rest of this hearing is less interesting because now it's pure gossip, and then the minority leader asks about the precedent she filed this motion under, which in my opinion is completely irrelevant to this hearing, because this is a Senate hearing regarding do they need some kind of legislation. So the statute, if it's faulty or not, is not up to this hearing to decide. That is up to Judge McAfee. So I'm not interested in what goes on in the last hour of this hearing. And frankly, it's just gossip. So, but this was amazing to hear not only the evidence gathered, but even evidence gathered that wasn't really admissible, as in evidence spiced up with gossip. And it's been amazing to hear. And I don't get, for the life of me, I cannot understand how the public opinion isn't more against Miss Willis. How people actually can stand by this district attorney who sleeps with her married subordinate, tries to hide it, lies about it in church. I don't care if it's not illegal to lie in church. You don't lie in church. No, you don't. You just don't. In my opinion, Fani Willis is a disgrace for the legal profession. A disgrace. She should have the integrity to step down, move somewhere else, get barred in there and start working as an attorney. Change name. I don't care. But she should never again work as a district attorney. Never. Okay. I don't have much more. Let me see who is online at this moment, or who is streaming at this moment. I don't actually know. Oh, Broken Baker. I will send you over to Broken Baker. If you don't know who Broken Baker is, he is a Danish professional juror. We have that system here in Scandinavia with professional jurors. He is elected for a 4-year term as a juror. So, yeah. So you can have his opinion on what's the case he's covering right now? Tennessee versus Robin Howington. That's the case he is currently covering. But first of all, thank you all for being here. Thank you for allowing me to try to translate these cases and trials to you with legal analysis and snark and fun. Because most trials are so boring. So I hope I can see you all back here tomorrow. Tomorrow is a fundraiser. Starts at 3 p.m. Eastern Time, and it is for the What the Hales case in Florida. And if you haven't heard about that case, you need to be aware of that case, because that is bonkers. So tomorrow, 3 p.m., fundraiser. It will involve the Wheel of Regrets. Nick, what's the Wheel of Regrets? This is the Wheel of Regrets. Tomorrow in the fundraiser, to the What the Hales GoFundMe for their legal fees. $100 to them, $25 to me, buys you a spin on the wheel.
Whatever it lands on, I will do it. Let's see if this had happened now, what would it have landed on? It would have landed
On a whiskey shot, yeah. And as you can see, there are scorpion sauce, tequila shot, habanero sauce. What else do I have? I have... It should be more here. Where are they? Wild sauce, wasabi paste. There it is. And stuff like that. And that is for pure entertainment. The main focus is to get some funds. I have already checked with the Hales about this specific GoFundMe, and they vouched for it, so I'm okay with it. If they hadn't vouched for it, I would never have held this fundraiser. I'm very picky with my fundraisers. It needs to be verified and vouched for. Otherwise, I can't put my reputation on the line for it. So that's for tomorrow, 3 p.m. Eastern. And until then, thank you again. Hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. Okay? See you tomorrow. Bye-bye.